Hi, good afternoon, madam. My name is Nilisa Manokaran. I'm from DLS 3B. This is my mind map. My topic for today is law of contract. First is type of contract, which is we have three kind of type. One is element of valid contract. Second is type of voidable contract. Third is illegal and void contract. Second is effect of contract. Valid, void and illegal and voidable. Valid must fulfill the element of contract. Void an element happen if one of the element is not fulfilled. Voidable made it or without free consent by allowed or not allowed. Number 3 is remedies of breach of contract. We have A, B, C and D, E. Damages, risk, reassertion of the contract, specific performance, injunction, quantum measure. First is difference between contract and agreement. Section 10(1). All agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. There are type of damages of contract. First is performance, impossibility, breach and agreement. So my case for this topic is Karupan Chetty v. Swantian 1960. Under Section 30, Contract Act 1950, provide that agree meets the meaning of which is certain or capable of being made certain and wide. Under case Karupan and Chetty, there's a section under 30. So my next topic will be legal aspect of business entity. We have characteristic, we have partnership, we have company, and also solo proprietors. Characteristic is formation, registration, management, liability, construction and dissolution. Partnership. Normally, if a partnership, there will be 2 to 20% under a partnership. Register under CCM under Registration of Business Rule 1957. And can claim under capital. Solo proprietors. Only one person running the company. Register business with CCM under Registration of Rule 1957. Can sue and can be sued in his name. Own regulation. So there's a right and duties of partnership. First is under Section 26A is expressed in writing and registration under the law if any for the time being in force for the registration of such documents, and it is made on account of natural love and affection between parties standing in near relation to each other, like husband and wife, parents, siblings, and so on. For my case for this topic is under company, which is private company worker are 50 and other company has no limit. Register with Company Commission of Malaysia as company under Company Act 1956. And the case for my topic, the case for legal aspect of business entity is Salomon v. A. Salomon and Co. Ltd. 1897. I'm so sorry. A shoe company have been incorporated by Mr. Salomon, in which he and his member of family were by the only shareholders. When the company business turned to be failure, the value of asset was insufficient to pay out both Mr. Solomon and the company other creditors. It's something like when we are running a business between our family members, like our parents, our husband and wife. If the company face any failure, there's something like we can share the failure money. We can share the failure money with each other, like if like husband and wife, there's an agreement, so the husband and wife can help each other to settle the payment. It's under section 26A. So my third topic is law of agency. Law of agency is, we have 5: necessity, emergency, express appointment, estoppel, implied appointment, ratification. Under ratification, we have condition of ratification. Ratification, the meaning of ratification is acceptance. It's like acceding without authority, legal, name of principle. So next we go for implied appointment. Is like from certificate of case, spoken, written, ordinary cause of delaying, estoppel, express appointment. So for law of agency, we have 2. One is by act of parties, another one is by operation of law. Act of parties, we have mutual consentence, and by operation of law we have bankruptcy, death, innocity, so on. Definition of agency is the relationship which subsists between the principal and the agent who has been organized the act of him or to do represent him to dealing the relationship. Agency is something like the middle person who deal with the party. It's something like I'm the boss, under me have one agent, another one is dealing with the business, something like that. It's we call as orang tengah. The case for this topic is Great Northern Railway v. Suffian. A horse was sent by rail, and on its arrival its destination there was no one to collect it. Insufficient to expense or stand by the horse to the night, it was held to GNR was the urgent necessities, therefore the case is under section 142. An agent has authority in an emergency to do all such act for the purpose of protecting his principal from any loss, and will be done by a person of ordinary prudence case in his own case under similar circumstance. Okay. Law of agency is something like we train one person as an agent for our business. Under case Great Northern Railway and v. Suffian. This case, the agent failed to collect the horse, so he is fined under section 142. Thank you. My final chapter, my last chapter, is sale of good. This is my mind map for sale of good. Okay. Definition of goods is under section 2. A Parcel of Goods Act 1957. Goods include every kind of movable property other than actionable claims, money, and includes. Contract of sale under section 4.1 of SOGA. A contract of sale of goods is a contract whereby the seller transfer progressive to transfer the property to the goods and buyer to a price. The protection to buyer and owner, we have nemo dat qua non habet, NDQNH, which means exception. Estoppel, sale of merchantable agent, sale of joint owner, sale by a seller possessiveness, sale by a buyer in possession, sale under a voidable contract. There are rights and remedies of breach of contract. One is remedies for buyer, second is rights of seller, third is remedies for unpaid seller. So let's we go for our case for this section. My case for this section is David Jonas B. William 1934. His merchantable quality. As the shop have been bought by description, here had been a breach of merchantable quality. He can be issued under section 1B, which is under section 1B, which is where goods are bought by description from a seller who deal with a good that is description whether he is manufactured or produced or not. There is an implied condition to the goods shall be merchantable quality provided that if the buyer has examined the goods shall be no implied condition as requires define which such examiner bought to be reviewed. The explanation is simple. Whenever we buy any product from anyone, there will be a merchantable quality. There will be an example for the products. If the seller fail, if the product which we buy fail as the product which shown by us, we can claim the product under section 100 under section 1B. Thank you. So, thank you, madam. Terima kasih.